The bridge nobody checked. The morning I became a landowner, I didn't celebrate. I drove out before sunrise, parked at the edge of what the auction listing had called an isolated landlocked parcel, and listened to the creek running somewhere in the dark below me. 1,500 acres of timber, silence, and one very specific paragraph that everyone else had missed. I had read that paragraph 11 times. What the maps don't tell you. Most people buy land the way they read terms and conditions. They scroll, they sign, they move on. I don't do that. 6 months before I placed a single dollar on this parcel, I lived inside its paper history. County GIS maps, surveying plats from 3 decades back, deed records tracing all the way to the logging company that had first cleared this timber in the late 80s, bankruptcy filings, title chains, the kind of research that makes your spouse call your filing system a mental illness and isn't entirely wrong. On paper, this land looked worthless: wilderness preserve on 3 sides, a residential subdivision on the 4th, no county road in, no obvious access point anywhere. That's why nobody else bid. That's why I did. Buried inside a 1994 deed amendment, one paragraph, easy to miss if you were moving quickly, invisible if you weren't looking, was a bridge. A single-lane crossing built over a creek by the logging company in 1991, deeded not to the county, not to any easement holder, but to the land itself. The subdivision on the other side had been using that bridge as their primary exit for 20 years. They had painted its railings, patched its deck boards, budgeted for its maintenance every single year. They had just never verified that it was theirs. The woman with the clipboard. 3 weeks after closing, I was walking my southern property line with a GPS unit when I saw them. 3 people standing on my side of the bridge. The woman in front held a clipboard like a weapon, pressed flat against her chest, chin level, shoulders squared. The 2 men behind her had the particular stillness of people who have been told they probably won't need to say anything. I recognized her from HOA meeting minutes I'd pulled during research. 9 consecutive years as board president. A woman who had once issued a formal written declaration that a neighbor's raised vegetable garden violated community aesthetic standards. I took my time walking over. She smiled the way people smile when they believe the outcome is already settled. She introduced herself, said the community had been eager to meet me, said she hoped we could start things off on the right foot, then she extended the document. 4 pages, clean formatting, my name already printed on the signature line. Community access agreement. Permanent right-of-way across the bridge in perpetuity, no compensation, no expiration, no renegotiation clause of any kind. I read every word while she waited. Then I took out my phone and photographed every page. Then I handed it back. The smile didn't break immediately. It took a moment, like a signal traveling a long distance before arriving. "Mr. Hale," she said, "this bridge has served this community for 20 years. I don't think you fully understand what you're dealing with." I looked at her for exactly as long as it took to be sure she heard what I said next. "I understand exactly what I'm dealing with, that's why I bought it." She held my gaze for 3 seconds, then she turned and walked back across the bridge, her associates falling in behind her. But before she reached the other side, she stopped, turned back toward the bridge structure, raised her phone, and started taking photographs. The machine was already starting, I could feel it. I drove home and called my attorney. Not to file anything, just to make sure someone else knew what had happened and when. The paper campaign. 14 days later, a certified letter arrived. 3 pages, confident legal language engineered to make the recipient feel the decision had already been made somewhere above their level of understanding. It asserted that the bridge fell within a * community easement corridor established in the original 1993 HOA plat map. It demanded I cease any activity near the bridge that might interfere with established community access. It suggested, in language that stopped just short of a direct threat, that failure to sign a right-of-way agreement would result in court action. I pulled my copy of the 1993 HOA plat map. The community easement corridor cited in the letter was a utility line easement on the northwestern corner of their own subdivision. It had nothing to do with the bridge, it wasn't near the bridge, it didn't reference the bridge in any way. The attorney who wrote that letter had either never looked at the document himself, or had looked at it and decided I probably hadn't. That was the moment I understood exactly what kind of fight this was going to be. Within the same week, the HOA filed a formal complaint with the county planning department, alleging I was conducting unlicensed commercial operations near a residential area. A truck parked near the bridge, survey equipment staged on the creek bank. None of it required a permit. None of it fell under HOA jurisdiction. My land sat entirely outside their subdivision boundary, not partially, not ambiguously, completely. The county opened an investigation anyway, because formal complaints require a response. An inspector came out, walked the site, reviewed my authorizations, and closed the file 11 days later with no findings. But the complaint had accomplished something that had nothing to do with permits or violations. It had attached my property address to the county planning system as a flagged location. It had created a paper trail that made my land look like a problem. And it gave her something to tell her community. The authorities are involved, we're handling this. She was building a story, I was the villain in it. What I found on my fence post. I almost walked past it. A camera mounted 12 feet from the bridge approach, commercial grade, weatherproof housing, positioned low, maybe 4 feet off the ground, angled upward toward the bridge deck and the access road. It was on my side of the property line. The mounting hardware was fresh. I didn't touch it, I photographed it from 6 angles, logged the GPS coordinates, noted the date and time, and walked away. Back home, I traced the serial number through the manufacturer's registration system. The camera had been purchased through a commercial account belonging to the HOA's property management company. 8 weeks earlier. 3 weeks before she had shown up on my bridge with that clipboard. She hadn't come to negotiate that morning, she had come to assess, and when I declined, she had decided to keep watching. Here is what she did not know. In this state and in most states across the country, placing a recording device on another person's private property without their knowledge or consent is not a civil matter. It is a criminal offense. The installation constitutes criminal trespass. The act of recording constitutes unlawful surveillance. The statute carries felony-level exposure with civil liability on top. I called my attorney the next morning. He listened to everything, the fake easement letter, the planning complaint, the camera. He was quiet for a long moment. Marcus, he said, they've handed you a loaded weapon. The question is when you want to fire it. I told him I wasn't ready yet. I wanted to see how far she would go. The community meeting. I wasn't invited. But Walt was a retired surveyor who lived at the eastern edge of the subdivision and had once told me he knew this land from county survey work years back. He went. He brought his phone. He called me afterward. She had stood at the front of the community room for 45 minutes, printed handouts, a presentation, a one-page legal analysis authored by the HOA attorney summarizing a doctrine called community necessity, the idea that a residential community's long-standing reliance on an access route created an implied legal right to that route, regardless of the underlying deed. Then she proposed a special assessment. $800 per household, collected immediately to fund litigation against me. A woman near the back raised her hand, retired paralegal. She asked to see the actual deed documentation supporting the HOA's ownership claim. The documentation is being prepared, the president said. What does that mean? Is there a deed or isn't there? We are working with counsel to establish the full scope of the community's rights. The assessment passed, 34 yes, 12 no. $160,000 authorized in a single evening to fund a legal battle built on a foundation that didn't exist. Near the end of the recording, Walt's phone caught something else. Her voice clear and steady in front of 46 people. This is a speculator trying to extort this community. Legal action will resolve this quickly. I listened to it 3 times. Then I called my attorney and told him I was ready. The filing. The civil complaint ran 34 pages, 5 counts. Defamation, the recorded statement made publicly, made falsely, made to a room that subsequently voted to spend $160,000 partly on the basis of it. Asterisk tortious interference, the fabricated citations, the baseless planning complaint, the manufactured legal pressure designed to disrupt my lawful use of my own land. Unlawful surveillance and criminal trespass asterisk, the camera purchased on the HOA's account installed on my property without my knowledge or consent. Abuse of process asterisk, the notice of interest filed against my title by the HOA attorney who would later admit under oath that it had been filed asterisk to preserve options while the matter was being researched. Not because a legal claim existed, to create one through friction. Quiet title asterisk, a formal court action to establish permanently and on the public record that the bridge over the creek was my property, not implied, not contested, settled. I also filed a criminal complaint with the county sheriff. The HOA attorney received service on a Thursday morning. He went silent for 11 days. What discovery found. There is a phase in civil litigation where narratives go to die. Discovery produced everything: deeds, emails, board meeting minutes, every communication between the HOA president and her attorney going back to the moment I'd declined that right-of-way agreement. The HOA attorney had sent that confident 3-page letter asserting a community easement corridor without ever conducting a title search. Not a partial search. No search at all. He had drafted a legal demand asserting property rights his client did not possess, based entirely on her representation that the bridge was community property. He had taken her word for it. But the emails were worse. A board member, the retired accountant, had raised a concern in the very first week after I declined the agreement. He had done his own digging, had found the 1994 deed amendment, had found the bridge transfer. He had written to her directly. I think we need to look at this more carefully before we proceed. The deed language is not what we assumed. Her response was 4 sentences. We have been using this bridge for 20 years. That establishes our rights regardless of what some old deed says. Do not raise this at the board meeting. And don't put anything else in writing. She had known, from close enough to the beginning, that the distinction barely mattered. She had known the legal foundation was hollow, and she had made a deliberate choice to suppress that information, proceed with the campaign, spend her community's money, and stand in front of 46 people and call me a speculator. All of it with full knowledge that the bridge was not hers. Courtroom C, 2nd floor. The quiet title hearing was a Thursday in April. My attorney presented the chain of title, 41 years, every link documented, every transfer recorded at the county recorder's office. The 1991 deed establishing the bridge as appurtenant to the parcel, the 1994 amendment, the 1999 bankruptcy transfer, the bank, the conservation trust, the state land authority, the auction. One bid. The HOA attorney argued equitable rights, 200 families, 20 years of reliance, an 11-mile unpaved alternative, severe community hardship. He argued it well, better than I expected given what discovery had done to his foundation. The judge listened without interrupting. Then she set down her glasses. Counselor, is there any written instrument, a deed, a recorded easement, a recorded plat notation, anything in the public record that grants your client a legal interest in this bridge? The pause lasted less than 2 seconds. It was its own answer. Not in recorded form, Your Honor. Our argument rests on implied easement by necessity and the equitable doctrine of. I understand your argument. I'm asking about recorded instruments. Is there one? No, Your Honors. She nodded once, put her glasses back on. Then we're going to talk about what the recorded instruments actually say. She ruled from the bench. No jury deliberation, no follow-up hearing. Right there in courtroom C on a Thursday afternoon in April, while the woman who had started all of this sat completely still in the gallery. The bridge was my property. The quiet title motion was granted. The notice of interest was ordered vacated and expunged from the public record immediately. The HOA was sanctioned $4,200 for filing a document asserting a legal interest in property without a good faith factual basis for that claim. The morning after. Court rulings become public record the moment they're entered. By Friday morning, the judgment was on the county court's online docket. The retired paralegal who had asked about deed documentation at that community meeting found it in 4 clicks. She posted it to the neighborhood social media group at 7:14 a.m. with one line above it. "I think everyone should read this." By noon, she had added the discovery emails, including the one that ended, "Don't put anything else in writing." The group fractured in real time. People who had written $800 checks, people who had been told the legal foundation was solid, reading, for the first time, an email proving their president had known the foundation didn't exist before she ever called that meeting. $160,000, gone, spent on litigation built on a lie authorized by a community that had been deliberately misled by the person elected to represent them. A petition for an emergency board meeting to remove her as president reached 112 signatures by Saturday evening. She didn't attend. Her own personal attorney, not the HOA attorney, a new one, had advised against it. The criminal investigation was still open. What followed? The criminal case concluded 6 weeks after the civil ruling. The sheriff's office presented its findings to the district attorney. The DA reviewed the camera, the purchase records, the GPS documentation, the installation on private property without consent, and filed charges: unlawful surveillance, Class D felony. Her attorney negotiated a plea to a reduced charge: criminal mischief, 18 months of unsupervised probation, a $3,500 fine, 100 hours of community service. Not prison, I want to be clear about that. But a criminal record, permanent, public, attached to her name in every future search, every future context, every future room she tried to walk into with a clipboard and the posture of someone who expected to be in charge. The civil defamation case settled out of court 8 weeks later, terms confidential. My attorney used the word asterisk meaningful when he called. He is not a man who uses that word casually. She resigned as HOA president on a Wednesday morning 3 weeks after the court ruling. 4 sentences: a desire to allow the community to focus on moving forward, no acknowledgement of what had happened, no apology to the homeowners whose money had funded a campaign she knew was groundless, no apology to me. Some people, when they finally lose, find a way to learn from it. Some find a way to exit the room without ever admitting they were wrong. The table in the community room. About a month after the quiet title ruling, I called the new interim board president, the retired paralegal, and asked if she had time to meet. We sat at a folding table in the same community room where 4 months earlier I had been called an extortionist in front of 46 people. She brought coffee, the 2 new board members brought legal pads. Nobody brought a pre-drafted agreement with my name already on the signature line. I want to be honest about the leverage I held in that room. I owned the deed to the only practical bridge connecting the subdivision to the county highway. I had won every legal action filed in connection with that bridge. I had a settlement in my pocket and a criminal plea on record. I could have installed a gate, I could have set a toll, I could have offered an easement at a price that reflected every legal fee, every sleepless night, every morning I'd driven out to that bridge to remind myself what I was fighting for. I didn't do any of that. What I offered was a recorded easement, permanent residential access for every homeowner across the bridge and the approach road, in exchange for a one-time payment of $18,500. That payment would fund a professional structural assessment of the 30-year-old bridge and seed a 10-year maintenance reserve held in the HOA's name. I would hold the deed, they would fund the upkeep, both parties would sign, both parties would record. A real agreement between 2 parties who both understood exactly what they were signing. The interim president looked at the number for a moment, then she looked at me. "I want you to know," she said, "that most of us never wanted this fight." "I know," I said, "that's why you're getting a real agreement instead of a gate." The board voted unanimously that afternoon. What the land became. By early summer, the land was working. Timber assessments completed, 340 acres of marketable hardwood, a sustainable 25-year harvest rotation developed with a forestry consultant, a sawmill lease signed in March. 8 hunting clients in the first season: whitetail deer, turkey hunters, waterfowl at the old quarry pond that had spent 30 years quietly turning an industrial crater into something that looked almost natural. Ducks had found it before I ever did. The conservation easement came through in June. 600 acres enrolled in the State Wildlife Corridor program, a trail connection extending a public hiking route by nearly 4 miles. A tax benefit worth documenting carefully. My private lender called in July and offered to refinance at terms a full point below my original agreement. I took it. On a morning in late August, I drove out before dawn, parked at the bridge, and sat with the windows down while the sky moved from black to gray to pale gold. The creek was running higher than it had been that first November morning. The structural assessment had rated the bridge at 40,000 pounds, better than either side had expected. Solid boards, good bones. Built to last. I walked to the center of the railing and